In this lecture, we will continue with the constitutional perspectives with regard to gender justice. On the one hand, we have seen that the preamble enumerates certain ideals and values with regard to the constitution and which the state has to uphold. In the other part, we have seen that there are certain fundamental rights guaranteed under part 3 of the Indian Constitution. These fundamental rights are heralded as the basic human rights, which are important for every individual to live and live well in society. In this regard, there are the right to equality, right to freedom, right against exploitation, right to life with human dignity, which lies at the core of gender rights in a sense of upholding women's rights and eliminating any form of discrimination against women. All these rights are enforceable and one can move to the courts of law for any violation of these rights, and it is the duty of the courts to ensure that these rights are upheld by the courts. We next come to part 4 of the Indian Constitution, which lays down the directive principles of state policy. These are included in part 4, as I said, of the Indian Constitution. In the way that they differ with the fundamental rights are, whereas fundamental rights cater to individual rights, the directive principles of state policy cater to the social needs. So, the directive principles of state policy are basically those aspects which the state must uphold in order to realize social justice and social security. These directive principles are contained in part 4 of the Constitution. However, they are not enforceable in the courts of law. In a sense, as we said, under Article 32, the fundamental rights are enforceable in the courts of law. As against that, directive principles do not have any enforceability. They are sort of directions, as we said, or goals which are there before the state, which the state should realize over a period of time. So, therefore, for any violation of the directive principles, one cannot definitely move to the courts of law for the enforcement of the directive principles. However, the significance lies in the fact that the directive principles are also fundamental to the governance of the country, and it is important that the various directive principles which are laid down must be realized by the state from time to time for the meeting the needs of the society and the state at large. Now, there are a number of directive principles which are aimed at the welfare of people, including women. So, whether it relates to equal remuneration, equal pay for equal work for men and women, or it relates to giving maternity benefit to women, there are several directive principles which have been laid down and which tend to achieve the welfare of the women and to see that the state makes necessary endeavor towards that end. Now, in this regard, one of the fundamental directive principles which I would mention, there are others, you can refer to Article 39 etc., which speaks of the other directive principles of state policy. One specifically which comes under discussion and is much under deliberation in recent times is Article 44 of the Indian Constitution. Now, this Article 44 of the Indian Constitution directs the state to secure for its citizens a uniform civil code applicable throughout the territory of India. In what, if we can remember in what sense it has been in deliberation in recent times, is on the issue of triple talaq. There has been a petition which is there in the Supreme Court, and there are arguments going on in which it has been held that the triple talaq is somewhere discriminatory to the cause of women, because there are hundreds and thousands of women who are a part of that religion and have been subjected to the pronouncement of triple talaq by the husband, and they have been left to themselves, and these women, in the absence of any economic resources etc., are left to fend for themselves and their children, creating a serious problem for them, for their life and for their well-being. So, therefore, the issue of triple talaq has been challenged in the courts of law. Now, where the issue of uniform civil code becomes relevant here, because the civil code or uniform civil code speaks in terms of uniformity in the application of civil laws, and application of civil laws speaks in terms of marriage, succession, adoption, divorce, maintenance, etc. Now, in India, if we know that in each of these aspects which relate to the personal law of a party, we are governed by our individual laws. So, based on religion. So, whether somebody is a Hindu, somebody is a Muslim, or somebody is a Christian, so on and so forth, we have individual personal laws which govern the aspect of marriage, the aspect of divorce, adoption, etc., etc. In other matters, let us say with regard to contract, with regard to property, etc., there are uniform laws throughout the country. Even in matters of criminal law, there is a sort of a uniformity in terms of the Indian Penal Code, the Code of Criminal Procedure, etc., being uniformly applicable for all persons. However, the only realm is personal laws, where if one is a Hindu, he will be governed by his own laws of marriage and divorce. If somebody is a Muslim, he would be governed by his own laws, and therefore, people who follow the religion of Islam are governed by their own laws, where this issue of triple talaq has a legal recognition, and therefore, the question of triple talaq in the discussion of uniform civil code becomes important and relevant. So, the issue is that Article 44 of the Directive Principles has laid down the necessity of the state to lay down a uniform code when it comes to the personal matters of individual. However, as I said, this is only a directive and it depends on the state as to when it wants to implement that. And over the years till date, we have not been able to make sufficient efforts towards that end. Just to quote K. Munshi of the Constituent Assembly, who had remarked that if the personal law of inheritance succession is considered a part of religion, the equality of women can never be achieved. Now, we have to understand the significance, because each of the personal laws, or in many of the personal laws, there are many practices, there are many systems which are in existence, which are derogatory to the cause of women. So, just as we stated the example of triple talaq, similarly, there has been the issue of conversion of person in order to contract a second marriage. Similarly, there has been issue of maintenance of women, and whether a person can claim maintenance under the regular law or under the Code of Civil Criminal Procedure. There have been these issues which have consistently come up before the courts of law. Many of you may be knowing the Shah Banu case and Sarla Mudgal case, in which the twin issues of maintenance of a woman after divorce and the issue of conversion of a man to Islam in order to contract a second marriage came up in question. Now, in each of these issues, it was seen that the woman was at the receiving end, because the woman in case of divorce is, as we said, is left all by herself, is deserted, many times do not have the economic resources for her well-being, and has to depend only on the maintenance which is payable from the husband. However, Muslim law allows for maintenance till the period of iddat, which is a stipulated period under Muslim law, but beyond that there is no such responsibility on the part of the husband. Now, that was called in question, as it was found that somewhere weakened the position of women and forced her to living a life of utter poverty, desperation, neglect, etc. Subsequent to the issue, there was an act which was passed with protection of women on dissolution of marriage act, which was passed, which tried to ensure that somewhere the concern of women is effectively addressed. However, even after that there have been numerous cases which have come up in the courts of law, Daniel, Latifi, etc., where repeatedly the issue as to whether section 125 CRPC can be invoked by a Muslim woman against her husband to make her to pay maintenance has been repeatedly petitioned in the courts of law. So, here we see one situation where women have found herself completely deprived, completely in a situation of penury, and the personal laws have somewhere come in the way of her well-being and her dignified living. Similarly, there was this case of Sarla Mudgal, where the husband converted himself to Islam, embraced Islam in order to contract a second marriage, because according to Islam, a man can marry up to 4 times and have 4 wives at the same time. So, that was brought in question, and the man who was a Hindu till then, the question for the wife was, how does she stand now vis-a-vis her husband, who had gone on to convert himself to Islam and thereby contract a marriage. Does the marriage stand vis-a-vis her husband, or the marriage stands dissolved, and whereby she feels whereby she has been deprived and her interest has been affected as a result of the act of the other person. So, here also the issue came up again of personal laws, which the Supreme Court tried to say that such conversions which are made only for the purpose of contracting a second marriage cannot be said to be valid, and vis-a-vis the first wife he would still be governed with the religion that he previously belonged to, and therefore, if that religion did not permit a second marriage, he would be liable for an offence of bigamy. So, therefore, the Article 44 lies at the at the core of women's rights somewhere, because it has a tremendous effect in terms of the various practices and the various rules which have been in existence in personal matters of individuals, which have somewhere had a negative impact for women, and has always considered women as a secondary being, and therefore not effectively address the cause of the woman. If the personal laws undergo a change or amendment in terms of the prevailing times, the changes which have come over a period of time, there is no difficulty with regard to the same, but the same is not true for all religions, as maybe we can take the example of even Christian laws which earlier were there and which were somewhat different when it came to men and women in matters of divorce, where the woman had to plead more grounds in order to seek a divorce from a man, but the man had to plead one or the other, a single ground, in order to go for a dissolution of the marriage. That was set aside, and there was the new change which was brought in, whereby such discrimination between a man and a woman has been done away with. So, somewhere Article 44 of the Indian Constitution, in terms of directing the state towards a uniform civil code, tries to establish also through it the equality of women, because it lies at the core of such such change. However, till date somewhere it has not been achieved, and that is where the directive principles we may not see its direct implementation or its immediate implementation. However, these, as we said, these are fundamental in the governance of a country. These are key goals before the state, and the state must take necessary and effective measures to see that these are achieved in the long run. So, if not today, over a period of time, these may be gradually achieved by the state. And it may also be mentioned that there have been several cases where the courts have tried to read in the directive principles within the fundamental rights. So, what we said, that fundamental directive principles do not have any enforceability as against the fundamental rights. The Supreme Court has tried to read in many of the directive principles, and therefore, in an indirect way try to include it within the scope of fundamental rights which is there, and thereby further the cause or the constitutional guarantees, further the constitutional guarantees for the protection of the individual in the state. In accordance with the change, there has been a change with regard to women's representations in local bodies. So, Article 40, which speaks of directive principles, the state shall take steps to organize village panchayats and endow them with such powers and authority as may be necessary to enable them to function as units of self government. Now, in this regard, there has been the 73rd and the 74th amendment, which has been effected in 1992, whereby reservation of seats for women in panchayats and municipalities have been provided in articles 243D and 243T of the Indian Constitution. And therefore, there has been a significant change with regard to reservation of seats, and so that women find an effective voice in the decision making process. So, this is also a significant change which has been effected by way of constitutional amendment. Lastly, in the constitutional aspect, we come to the fundamental duties which have been added in part 4A of the Indian Constitution, and this has been inserted by way of amendment, and these are fundamental duties of the people of the country, the citizens of the country, and where they must ensure that just as they have rights, they must observe certain duties for the betterment and the well-being of the state and the nation as a whole. Now, with regard to women, there is one specific fundamental duty which has been included in 51AE, which is related to women, and it says that it shall be the duty of every citizen of India to renounce practices derogatory to the dignity of women. So, this one aspect speaks volumes in terms of the responsibility of every individual of the country to ensure that equality of women is established and to ensure that discriminatory practices are abolished and to see that there are no situations of violence against women which happens in the society. So, therefore, every Indian citizen is under an obligation to see that they renounce practices which are derogatory to the dignity of women. So, whether we speak in terms of sexual harassment, sexual abuse, domestic violence, or we speak of prostitution or a plethora of such practices which are presently existing in the society, then we see that these are all violative of the responsibility or a sort of an obligation which has been imposed on the citizens of the country. They are to renounce such practices and to see that the dignity of women is maintained. However, it may again be mentioned here that these fundamental duties do not as such have any enforceability. They are merely laid down as a part of good behavior and practice which should be maintained or which is expected of every citizen of the country, and it is important that the citizens on their own ensure that they abide by these fundamental duties which are laid down. But other than that, there are no such obligations in terms of enforcing it in the courts of law unless the court wants to read these fundamental duties within one or the other constitutional provision which is there and thereby try to establish that as being applicable in the court of law. However, the constitutional responsibility or the constitutional mandate is quite clear. It speaks of equality of the sexes, it speaks of any absence of discrimination between persons just on the grounds of sex. At the same time, it speaks of a positive approach or a positive actions on the part of the states to ensure that effective measures are taken for the promotion and protection of women. Effective laws are in place, derogatory practices, demeaning practices and humiliating practices are abolished, while at the same time promoting the cause of women through various means and mechanisms, and therefore, all these measures have gone a long way in making the laws, in the implementation of the laws, which we will see in the next lecture.